So maybe as the moderator of the first session, I will call our first session to order. So if the BTLJ BCLT people can do the magic and get us all organized, I will then introduce this session about intellectual property issues involving right to repair. This is a space that I think some people would have thought, hey, of course I can repair my things because I own them. But it turns out to be a little more complicated than that. And so we have four terrific experts to talk with us about the intellectual property issues that arise in the right to repair context. I'm going to do this in a little bit different order than was on the program. So we will start with Bob Gomulkiewicz from the University of Washington, and then proceed with Josh Sarnoff from DePaul University, and then Kit Walsh from the Electronic Frontier Foundation, and finally Leah Grunwald from Suffolk University. And so with that, let me say, you should look at their biographies because it's really great, but I want to make sure that we spend as much time on substance as we can. So please, Bob, give us your remarks.
All right. Can everybody see the screen that hopefully I shared?
Yes.
All right. Well, Pam and Aaron, thank you so much for inviting me to be on this panel. And I have to say that I really started studying the right to repair way back in 2020 when Aaron and Pam invited me to participate in this panel. And what I discovered when I started digging into the issues is that people like Pam and Aaron and other distinguished people on this panel, Kit, Josh, Leah, have all been making significant contributions on a variety of important issues in right to repair. But as I started studying the work that's been done, I noticed that people were very aware that software was an important part of the equation. And in fact, there was a lot of discussion about the Digital Millennium Copyright Act, about diagnostic software, security codes, but even in those discussions, I didn't see anybody addressing what seemed to be the most emerging issue, which is, should there be a right to repair software? And the reason that I was focused on that issue is, as we think about smart goods and we think about the value of smart goods, we should be thinking about the software as much or more than the hardware. So what I want to do today is dig into that issue and think about whether we need a right to repair software. And so to do that, I want to really draw on the over 3 decades of experience I have in the software industry to really talk about the ways that the software industry is already addressing software repair. And hopefully you'll see that the discussions and the activity in the software industry around repair have been and continue to be very vibrant and robust. So I at least want to bring that information into the conversation, the bigger conversation about right to repair, so that we can all be on the same page as we're talking about software repair. And in doing that, I'll talk about practical issues of software repair, as well as the type of intellectual property issues that Pam mentioned. And then I want to conclude by looking forward and really thinking about what could we add to the current efforts on software repair. What could we do to improve the climate for software repair? So to really tackle this topic, I want to go through several different points. I want to do a little bit of background on software forms, storage, and distribution, just so we are all talking about the same thing. And then I want to dig into the legal and practical challenges that we face when we talk about software repair. And that will lead into a discussion of the existing software repair landscape. And then let's step back after we have that background in mind and really ask the question, do we need a legislated right to repair software? And I want to explore that question. And then I also want to explore a different question, which is, how can we reframe a right to repair software in light of some of the realities, the challenges, the legal and practical challenges about software repair, and reframe it in a way that might allow us to make better decisions about whether we need regulation or legislation, or whether really the market is acting sufficiently to take care of repair. All right, so just a quick tutorial on software for those of you who are programmers. This is old news, but for those of you who are not, here's a quick software tutorial. When we think about software forms, the first way to think about it is the source code, and that is the human readable code that programmers write and programmers understand. Now, most people don't really understand source code, but if you're a programmer, you do. And I focus on source code because most of the time, access to source code is essential to being able to software. Now, the software that we typically work with comes in object code form. It's machine readable code that comes distributed on devices, on disks, and in other ways. And so typically, we as users encounter object code form. Also notice the visual displays that it generates. And nowadays, we sometimes forget that we even are using software. We just experience the service that it provides. And so a lot of people call this software as a service. So for software to work, it has to be stored and distributed to us in various ways. And I just am taking us through a quick history of that. It started off with punch cards and punch tapes. I gave you a little picture, historical picture of a stack of punch cards. And then it progressed over time to being distributed on different types of disks, large floppy disks, and then smaller diskettes. And then over time, the software was distributed on hard drives of computers, and more, and now taking up to the present, more and more software is embedded in devices of all kinds, everything from cars to tractors to phones. Another way that software is stored and distributed is on servers. It's out there somewhere in a remote location, and the device that we're using is going out and either running the software off of that server or pulling down the software from that server so that we can get the services we want. So these are all the different ways that software has been and will be stored and distributed. And if we really think about the future here, we are really talking about a trend toward more and more software being stored on smart devices. And Pam and Aaron both read that in their introductions, and I'm just giving you a picture of a car here. But on the other end of the spectrum, more and more software is remote to us. It's not on the devices that we own, but it's being run out there somewhere in the cloud, on the series of computers out there and maybe even distributed around the world. So I point that out because, as we'll see, that presents some practical challenges in right to repair, that trend towards software being stored and distributed in devices and also in the cloud. So let's start off with some of the practical issues about software repair. And again, if you're an expert in software programming, this is old news to you. But the first thing to say about software is that it has bugs. It always has bugs. And you might even say that software is always broken. It's always in need of repair. It's constantly in need of repair. And so that makes software a little bit different than hardware. And then just to compound the practical issues, if you read books on software testing and software diagnostics and repair, what you're going to discover is that software repair is more difficult and more treacherous than hardware. A fun book to on this that's pretty accessible is Frederick Brooks's classic work, The Mythical Man Month. And he talks about how seeing one bug often leads to another bug, often a more severe bug. And he describes the process where repair, especially as the system matures and gets big, as really one step forward and then one. So that is just the reality of software repair. It's difficult, it's treacherous, and more so than repair. And then the further complication is that embedded software is difficult, if not impossible, even for experts to repair, because it's difficult to get back to the source code that you need to actually make the repairs. So the more software we have that's embedded, the more difficult it is from a practical standpoint to get the actual form of the source code that you need to repair the software. And then even more challenging is software that's in the cloud. It's out there somewhere. And again, getting access to the source code is impossible or difficult. And so those are just some practical challenges that we have in repairing software. And again, I just want to contrast that with hardware repair, which has, I think, been the focus of the right to repair movement up to the present time. Okay, what about legal challenges? Well, software is protected by all forms of intellectual property. And for the purposes of the short time I have today, I just want to focus on copyright and trade secrets. But I don't want to ignore the fact that software is also influenced by the Digital Millennium Copyright Act when a software provider uses technical protections. Patent law comes into play for some software, and contracts also come into play. But today, I just want to focus on copyright and trade secret because those are really two of the most important intellectual property protections for software. And for copyright, the Copyright Act, as you know, gives copyright holders the right to control the making of derivative works and the distribution of the software itself and derivative works. And so if we're talking about a right to repair software, those two important copyrights come squarely into play. And then trade secret. Many companies hold their source code as a trade secret. And so if we're talking about a right to repair software, then we may be talking about the disclosure and use of important trade secrets of software companies. So I'll get into those topics in a little bit more detail in my presentation, but I at least want to highlight at the outset that we have to confront those significant intellectual property issues when we talk about right to repair. Okay, so let's spend a few minutes though talking about existing software repair channels, because I think that sets the stage for considering this question of whether we need further legislative or regulatory activity. And so let's start off by saying that in the early days, people shared source code on a regular basis. And so as people were repairing software, it was relatively easy because when you shared software, you were, of course, sharing source code. And that's because it was pretty much sophisticated people that were making and using software. But as businesses and less sophisticated people started using software, the repair landscape had to. And first it evolved in providing service contracts for repair. And so businesses that use software would hire programmers or companies to do the repair for them. And then we start moving into the 1980s and software starts to become a mass market product. So not just available to a few businesses, but many businesses of all sizes and consumers. And so then the repair landscape had to evolve further. And so what we see are software companies coming up with a variety of strategies to provide repairs to customers, including maintenance contracts, distributing repairs through value-added remarketers, through OEMs, through systems integrators. And so just a variety of ways to get repairs out to customers. And then we even see large businesses such as EDS and Perot Systems sometimes actually taking over the maintenance of an entire infrastructure for large companies. And so businesses emerged that really focused on hardware and software maintenance as a business, just to take that headache away from the customer. And then we might say that the software repair landscape evolved even further in the internet era, because then software companies could make repairs available for download on their website. And so that was a big breakthrough. And so companies were always putting repairs of different types up on their websites, available for repairs, and making their customers aware of that availability for download. And then as things evolve further, we see that not only did software companies make repairs available on websites, they started pushing the repairs to customers so that the customer didn't have to go out to the website. The repair came to the customer, was pushed to the customer. And in I'd say the most recent version of that, a lot of repairs now operate automatically. Just the other day, my iPhone operated automatically to update my iPhone, whether I wanted it to or not. And so now we're kind of in the era of automatic updates that come to us over the internet. And so those are some of the ways that that software companies have been making and distributing repairs out to their customers over the last few decades. And let me just mention a couple of other ways that it's happening as well. Many software companies now are providing subscriptions to their software. And so in those subscriptions, you automatically get any repairs, any update software, or in an environment where you're just subscribing, the same is true. If there is a software update, you automatically get that as part of the service. Okay, I want to mention just a couple other parts of the landscape and source code license. I mentioned way back since the dawn of the software industry, people have been licensing source code on a basis, but now we see the emergence of a set of licensing practices that we call open source licensing, which I'll describe in further detail, but those source code licensing practices are.
Bob, I'm sorry to interrupt. This is really fascinating, but we only have an hour for the whole panel. So could you take 1 minute to kind of do a synopsis, and then we'll move to the next speaker? Thanks very much.
Yeah, thanks, Pam. Sorry, I lost track of time a little bit. So I think what I want to say as we think about this question about the right to repair software is, are these ways that we're doing providing repairs, are they robust enough? We already have a robust market for providing object code repairs. We already have pre-existing channels for source code. And in particular, the open source movement encompasses repair rights. And so as we're thinking about whether we need a right to repair software, I think it's important to just know that we have these avenues already in place. And so let me just jump to my last slide. And so I think as we think about things that we might want to add to this landscape, we might want to reframe a right to repair software to focus on a couple of issues. And one is maybe a right to receive repairs for a certain period of time. And another one is maybe the right to revert to a prior version if we want to. And I focus on those two issues because those, I think, are most relevant and accessible to consumers. And I think that we'll see that maybe when the panels start to focus on developments around the world, particularly in Europe, this is the direction that some of those developments are going. Thanks, Pam.
Thanks very much. Josh, why don't you take us to the FTC and its role? Thanks.
Sure. And I'll get there in a broader context. Let's see if I can share this. And I just want to emphasize that, something that Pam and Aaron said, which is that this is an optimistic time, but I'm going to focus on one of the real difficult problems in one of the most costly and important areas, which is car repairs. So, as many of you know, design patents protect new and original and ornamental designs for an article of manufacture, but because without this protection, people are free to repair at least the aesthetic appearance of all sorts of products. The problem of granting these patents is increasingly to limit the aftermarket for third-party manufacturing of parts and then increase the costs to consumers, and in some cases make those parts unavailable so that they simply can't restore their cars. But again, the same is true of people know about the famous Apple v. Samsung design patent litigation, which is really about the amount of money involved. But the same principles apply. It's just that the car market was historically an extremely big market with a large and robust repair market that's increasingly being constricted by the grant of design patents. All of this traces back to a 1980 case which allowed patents on parts and fragments of an entire thing. Design, as many of you know, is something that we perceive as a whole thing, but this allowed obtaining patents on smaller and smaller pieces. And the consequence of that was to reduce the size of the object that could be considered remade or manufactured, and therefore the part itself became the thing that's being reconstructed rather than a part being part of a larger repair of a larger object. Rhetorically, this was a way of shifting the consequence of the grant of rights onto the consumers by saying now consumers are actually engaged in theft, or third parties are engaged in theft when they were producing things that people otherwise would have had a right to do. So this is why it matters. There was an effort in a case called Automotive Body Parts Association to try to restrict cosmetic repair parts by arguing that these are actually functional in the sense that consumers actually care that there's a matching of the parts to the things that need to be repaired, and the court rejected that. Again, there's all sorts of problems with design patent law that I'm not going to go into, but this made the problem even worse. And it also failed to recognize that for many parts, particularly for consumer car parts, insurance contracts require that you provide a part that's of like kind and quality. So that really means that you have to either obtain original equipment parts or obtain parts from a licensed manufacturer or obtain infringing parts. And again, the original equipment manufacturers are increasingly exercising those rights to prohibit imports, even though they may be produced legally in other countries for the same products. Many of you may know of the important Impression Products case, which dealt with exhaustion. This actually prohibits the patent rights from being used against the owners when they've purchased their cars from making repairs through contractual restrictions, although there's some question as to whether or not those original equipment manufacturers could actually impose repair restrictions and try to enforce them through bilateral contract lawsuits. Typically, they don't do that. But much more importantly, because these are federal rights, state law, right to repair laws that would explicitly protect third-party manufacturing and access to the repair parts are likely to be found preempted. So the question is, what can we do about this? And again, the good news is that the FTC likely has authority here, but the bad news is they're, notwithstanding the Nix the Fix report, particularly in the context of design rights, I think they're unlikely to exercise this authority. As we know from a different case called Activist, that conduct that's within the scope of the patent may still be a violation of antitrust laws. Here, we have both monopolization of the parts market and potentially illegally tying the parts market to the service market. And those could also be addressed by the FTC under Section 5, which provides for adjudication actions to address unfair methods of competition. There's also Section 6G authority that potentially allows for rulemaking to address this. But again, these are explicit rights that Congress has granted to prohibit imports and prohibit making. So it's unlikely that they're going to, I think, override explicitly granted rights. Similarly, the idea that companies can use their intellectual property rights to take away repair rights should be understood as unfair to consumers. But there's a long history in the FTC of being resistant to exercising and utilizing its unfair and deceptive commercial practices authority, precisely because when they tried to do so, Congress held oversight hearings, threatened them by taking away their money for a little while. There was legislation that made rulemaking quite difficult that was adopted in 1980. And I think the FTC is just a little bit gun shy. So where does this leave us? It leaves us with the need for a legislative fix. There has been pending for a long time a particular bill that would address the particular context of car parts and only exterior component car parts. And it would allow it not to be an act of infringement to make or sell any article of manufacture that would help you to restore your car to its original appearance. And you can't, for 30 months, actually offer that to the public. So it gives the original equipment manufacturers an exclusive on parts repairs for a short period of time, or their exclusive licensees. But there are other ways that Congress could simply adopt an explicit right of repair that supersedes the Design Patent Act. But this requires political will. And, the key issue here is design patent laws unfairly deprive consumers of the right to lower cost third-party repair parts. It needs to be changed for any number of reasons, including this, but getting legislation is just hard to do. So I'll look forward to hearing more, hopefully, from our antitrust experts about why the FTC is going to take action. But until that happens, the largest aftermarket has, effectively been shut down. Consumers are paying through the nose, and it's time for lots of people to stand up and protest to try to get their Congress people to pass legislation, not just to address this problem, but to address repair more generally. It's just that this is such a big market, and so many people depend on their cars that one hopes that if we can't get general repair legislation, at least we can move this. And that's all I have to say until questions.
Thanks so much, Josh. That's terrific. And we go now to Kit Walsh, who has some experience actually working on trying to get right to repair through a rulemaking process that Kit will explain. So take it away, Kit.
Absolutely. So I work at EFF, which is a civil liberties organization dedicated to ensuring that new technology enhances liberty rather than impinging on it. And to that end, for decades, we've worked to promote the ability of experts and the general public to understand and modify the technology that governs so much of our lives. Because if the law says that no one's allowed to understand or change how devices work, that shifts the balance of power really dramatically in favor of the companies that make the devices, and they may want to collect your private information. They may want to lock you into their ecosystem and monopolize the parts aftermarket, and otherwise just make sure that your devices serve their interests above yours. That extends also to the context where you have a government order going to that company to turn on a camera in your living room or shut down your mobility aid at a protest. In the 21st century, it's really important that we have loyal computers that we can audit. We can make sure that they're serving our values instead of the values of the manufacturer. So the right to repair is a piece of that larger puzzle from our perspective. And we've been fighting for the right to repair for some time, and particularly in the context of Section 1201 of the DMCA, which you've seen sort of creeping around the presentation so far. And now we're going to shine a light on what it is. It's a law that was enacted in the late 90s when Congress was convinced to be afraid of online infringement of entertainment products. So Congress had in mind this idea that you might like descramble a cable channel you hadn't paid for, or rip a DVD and upload it, and was convinced, I think wrongly, that new legislation should be enacted to say that there is a new cause of action for a rights holder, as well as a criminal violation if you access a copyrighted work without authorization. And in doing so, have to bypass a technological protection measure. So you might have heard of DRM, digital rights management, that's applied to entertainment products. It can refer to anything that's behind technology that keeps you from looking at, accessing the thing. And that, of course, includes encryption. And so if you have an encrypted copyrighted work, such as software in your car or other product, this is a law that says you might go to jail if you read it, if you bypass the encryption to make it intelligible and look at that code to understand what the car does, to repair it, to do whatever you need to do with your car. And of course, encryption is great. I want the software in my car to be encrypted so that someone walking by can't change it. But the question is, who has the keys to that encryption, and who's allowed to have the keys to the encryption? So I want to be allowed to have the key. I want to be able to give the key to my independent repair person who I trust, or who's more convenient or cheaper or whatever, and make that choice that I'm not going to only have the option of putting all my trust in the original vendor. I'm actually going to be able to see how the thing works, to learn from it, to engage with a competitive repair aftermarket. And people in that aftermarket are going to be able to understand the technology so they can make better competitive diagnostic tools. So with all this in mind, back in 2015, EFF went to the Copyright Office, which every 3 years conducts a rulemaking to potentially grant a temporary exemption that will let people circumvent to achieve a particular purpose that we were able to persuade them is legitimate. And so we started with cars. And one of the reasons for this is that people have been repairing their own cars for 100 years. So when the manufacturers come in and say, oh, no one knows how to repair cars, or it's too dangerous to let anyone but us repair cars, they wind up looking silly. And we were doing this in concert with a number of law clinics who were specifically focused on tractors and other agricultural equipment. And so if you have heard about the outrage over John Deere saying you don't own your tractor, this is the poke that provoked them into saying those outrageous things, which they have not backed down from. But fortunately, through this rulemaking, we were able to succeed. And so what that means is Section 1201 is not an obstacle to the act of circumventing in order to diagnose or repair or create a lawful modification to the software that's in a vehicle. And that was expanded to vessels as well. So you can be on land or on water now. But what it doesn't do is interact with another provision of Section 1201, which is the ban on trafficking in circumvention technology. So, so what that means is the tools that would enable an independent shop to do the circumvention, or you in your garage, are not subject to this protection. And so they remain in this legal gray area where the manufacturer might be able to sue you for providing that service or technology. And this isn't sort of an idle concept. Household names like Philips and Ford and General Motors have all brought 1201 based lawsuits to shut down independent repair. Philips sued a independent medical repair group during the pandemic, and 1201 was the legal hook that they had to do that. So why is copyright in my car? It's because the software is in there, and the software is in all of our technological devices, and it's probably copyrighted, and it might be subject to a technological measure like encryption. If it's a secure device, it probably is subject to encryption, but the companies might not give us the keys. And so part of what we had to show in this rulemaking was that it would not be an infringement of copyright to achieve these repairs. And now I'm gonna speak a little bit to what Bob was saying earlier about repair of software, because simultaneously we were also seeking the right to do security research and safety research and testing and patching for vehicles at the same time. And that is a form of diagnosis and repair. You figure out, is my car, are the brakes going to fail because of a bug in the software? If so, I get to fix it. As well as the question of, when I replace the tires, I need to access the software to change something to get it to understand that there's a new radius of the tire, and for the computer to understand how much sort of distance is being traveled per rotation of the tire. And there were also people who, we had a bunch of great sort of anecdotes from people around the country who would say, I need to change the software in my car to make it work properly here in Alaska. And it was charming. They were talking about how they had to get the bear on the hood of their car home in time because they had been hunting. It wasn't a passenger. And we had people sort of talking about their real world needs to customize the device, which is made to suit sort of the broadest segment of the market and not sort of edge cases. But people who are edge cases exist and need to be able to use technology. And this is one of the ways that they do that. So we established non-infringement, arguing both that it was a fair use under copyright laws, traditional copyright law about what you're allowed to do with software. And a big part of that argument is when you're talking about embedded software, I can't download a tractor and take away from John Deere's market for selling tractors. You wouldn't download a car because you can't download a car. And so that was a part of the argument, which we later extended to, in subsequent rulemakings, to other consumer devices. Basically, when you have embedded software, that's a common factor in the fair use analysis that weighs in favor of fair use. We also argued that it was authorized under Section 117, 117C, which provides for a pretty convoluted, I thought about, should I have slides so I can show people Section 117? But I think it's an abyss that will just suck you into confusion. It is a law that provides some scope of ability to patch, repair software that you own. In the Second Circuit, it includes the right to update the software to keep it useful to you under the Kraus v. Title Serve precedent. And that's sort of an important, I think, starting point, both when we're talking about strengths and weaknesses of a right to repair for software, which I think we absolutely should do. So, like I said, we started with cars. We added, 3 years later, we went back and we got home appliances, and 3 years later we got back, and now we're at the point where you can do the diagnosis and repair for consumer electronics. They won't let you do non-infringing modifications outside the context of the vehicles. But there has been progress in terms of this legal obstacle to achieving repair, which is sort of the low-hanging fruit, right? If you're thinking, how do we achieve good competition policy? You can start by not outlawing the necessary steps to have a competitive marketplace. And Section 1201 does that. It still does that. It should be repealed. That, is an easy, simple fix. But sort of another, as we think about other things that can happen at the federal level, I would love to see protection for sharing of information like repair manuals. So you stop seeing cease and desist letters from people who are trying to enable usually their fellow independent repair people from repairing devices. This was a problem in the midst of the pandemic with repairing medical devices. And I think Section 117 may be a starting point, but it could use some updating and clarifying. And then that's all federal law. So the states have been tackling a slightly different problem, or at least going at it from a different angle, trying to ensure the availability of repair parts and information. So in part, that lack of information is caused by the ban on reading the code. So the companies that would otherwise make diagnostic tools don't get to look at the code and figure out how it works in order to do that. But even without the ban, it's just sort of more efficient for the competitive marketplace if that information is more available. And that's where the legislative fights in the states have been, as well as the focus of some of the federal right to repair legislation. So to give you a sense of the politics of it, you have consumer advocates, independent repair people, environmental interests, e-waste recyclers sort of advancing the bills. And consumer advocates could mean farmers and farming groups whose livelihood is impacted when their $200,000 tractor is down for a whole day because it takes that long for the John Deere repair person to get to them. And then it's manufacturers who are opposing them, especially the ones that have a licensed repair program and a revenue stream along those lines. So I think in addition to sort of what's been in the legislative proposals at the state level, it's also within their power to do more to make sure that contracts of adhesion, like EULAs, can't serve as a barrier to competitive repair, reverse engineering, security research, or interfere with the rights that attach to the owner of a device or the owner of a copy of a copyrighted work. That is all, at least arguably, within the scope of state contract law. And so I would love to see that become a part of the model bills as well. But it's been a really exciting time. Like Aaron said at the start, a lot has changed since 2014 is when we filed our petition for the right to repair vehicles, and hopefully some more will change in the coming years.
Great, thanks very much. That's just a terrific overview of the anti-circumvention rules element of this. And Leah Grindvold is going to now take us to thinking a little bit more about the kind of international and enforcement at the border. So take it away, Leah.
Thank you so much, Pam. And thank you to my co-panelists, Aaron Przanowski and the Berkeley Tech Law Journal's students. Everything has been so great logistically and just so interesting so far. So I look forward to the rest of the panels and next Friday as well. So my co-author and I have been working on IP and repair for a while, and we're sort of making our way through the various topics. And this topic, actually stems from experience that I've had when I was in practice as an in-house counsel, and so I'll bring that up as I go through. But basically, our thesis for this area is that IP rights and aggressive border protection are stymieing repair. And so, how is that happening? Manufacturers are increasingly obtaining IP rights over repair parts, right? Josh sort of has mentioned that in the context of car parts. It's a big problem. And there are also in other areas, a lot of consumer products as well. But then these manufacturers are then allowed to utilize federal governmental agencies like the US Customs and Border Protection Agency, as well as the International Trade Commission, in order to enforce these rights at our border. And why is this a problem? Well, when they enforce these rights through these agencies, parts that they claim are infringing their intellectual property rights are detained and in most cases seized by CBP. And this results in repair parts not being available to independent repair organizations. And as we know, some folks have mentioned in passing, these repair parts are not readily available on the open market. And as Kit just mentioned, state law is trying, there are state law measures trying to enforce this or to make more available parts, but these pieces of legislation have not been passed. So just going into that argument, IP rights over repair parts, this, in this piece, my co-author and I aren't going to be sort of examining the arguments against providing these rights. We've done that in other work, and Josh, I think Josh's work has done that too with respect to repair parts, carpet repair parts. This is a fact, right? That repair parts have intellectual property rights on them that then allow the manufacturers to utilize them to enforce. So, for example, placing microscopic trademarks on parts that you need to repair. Oh, you can't see on the screen. Let me show you right there, right? So you can see how tiny it is. Clearly used to be able to claim the ownership over it, that nobody else can make that part or import it, let's say. But more recently, manufacturers have been obtaining rights on the repair part itself. So design patent on the hood of Ford's F-150 pickup, or trademarks on their grille, or even Volvo's backlights here. And so, as I mentioned, what these rights allow the manufacturers to do is utilize the governmental agencies such as CBP and ITC to undertake enforcement actions on their behalf. And so, this is, I've not really found too much literature on this topic. And so I draw a lot on my own experience in this area. But some of you may know that once you have registered trademarks and copyright, you can then record them with the CBP, which is gets it entered into their database. As well as for ITC, you can bring a claim and ask the ITC to investigate infringement of trade dress and patents, both design and utility patents, excuse me. But for those of you who aren't familiar with how these agencies work, I'm going to just do a brief primer. The CBP stops shipments that if you obtain an exclusion order from the ITC, or if one of the shipments sort of pings from their database a trademark or copyright that was registered. And when they suspect that a shipment is coming through that is infringing, they detain it, right? And so what you don't know, though, what you may not know, is that while they might suspect that the shipment is infringing, they actually look to the manufacturer for assistance, right? So they'll send them an email most of the time, maybe give them a phone call, the in-house counsel that's on record. This is where my experience comes into play. And they'll ask them, right? They'll say, hey, I'm going to send you an email with some pictures. They're not always the highest of resolution pictures, to that matter. Can you let me know, is this infringing? And you, as in-house counsel, have the discretion to review it and say yes or no. And there are no downsides to saying yes, right? There are no repercussions. There's no, requirement that's put on the manufacturer, the in-house counsel, to say yes. Obviously, you have a moral, ethical duty to do your best, but otherwise, if you lean on, the side of maybe a little more aggressive, right? And we all know that many of the manufacturers out there are, then you say yes, right? And you're more on more conservative side. So, and this stops, then this confirmation allows the CBP to then seize the shipments and not then provide them over to the importer. Now, this is where it comes, where the stymieing of repair comes into play, because the importer typically is the independent repair shop, right? They're reaching out, they're trying to obtain repair parts internationally because they're just not available domestically by the manufacturers themselves. Sometimes, yes, sometimes they are counterfeit and they should be seized. Oftentimes, though, they're refurbished or gray market products, right? That they're sold abroad and then purchased by others who then will take parts out of returned products and then resell them on the market. And so these, as long as they're not materially different, and they're likely not because they're being used to fix consumer products or cars or tractors in the US, as long as they're not materially different from what is being sold and used in the US, they are not infringing. And yet we see these claims of infringement happening regardless. So, these overclaiming, the overclaiming of infringement by manufacturers with no repercussions is really harming repair. And so what are some possible solutions? I mean, we can brainstorm a number, and these are not mutually exclusive. And so at Customs Border Protection, perhaps increase the burden on manufacturers to prove infringement, right? Maybe you'd want to require signed affidavits. Right now, it's simply, an email confirmation or even a phone call. Perhaps maybe a posting of a bond in case the importer can prove non-infringement, right? That once the manufacturer says or confirms that the shipment is infringing, the burden then shifts over to the importer to prove non-infringement. And that's a heavy burden, not always happen, most of the time does not happen. Most of the times if it's a small repair shop, they don't have the resources or even the know-how to figure out what they're supposed to be doing. And so that oftentimes, but if they are able to do so, maybe then having that posted bond will just put some weight behind the manufacturer's accusations. At the International Trade Commission, I want to point you to two great articles on this topic. A little old at this point, right? Because the repair movement is moving so fast, but the ITC not. My changes of the ITC not moving as fast as the repair movement. And so Colleen Chan and Mark Lemley have a great article from 2012 where they talk about patents and the ITC. And then Tom Cotter has a reply to that article where they go through a number of different ideas, all the way from tweaks that the ITC can take, like delaying implementation of exclusion orders, all the way to abolishing the agency. And that was from Professor Cotter's argument. So thank you for having me be part of this panel, having me be part of this great conference on repair. Comments, questions are welcome. Thank you.
Great, thanks so much, Leah. So we have 6 minutes left in this session, and lots of questions. But I think I'll try to hit a couple of them and then offer the opportunity to respond. So one of the questions has to do with something that Bob raised about allowing people to reinstall or downgrade. And the person who posed the question suggested that users are unable to revert even if they find a bug or a feature they don't like. And that's particularly true of a lot of Apple products. So that's one question. Maybe a little to Kit and a little bit to Josh, whether and maybe also Bob, is fair use going to help to take care of some of the copyright or 1201 problems? And what about abuse of right in respect of patents? So let's try to be succinct about this, but at least a couple of the questions that were posed are worth, I think, some attention.
Pam, if I can just start, I'll just give a couple of reactions to that. The first one is I agree with the person who asked the question. I think what there is a right to revert it's not clear. And so I think that is a very fruitful area for regulatory and legislative activity. I've started to now look through the end user licenses and other policies of the top software products, and it's not clear what right you get to revert. And so I think that's a weakness. And I think that is a very fruitful area of exploration. And I do think it's a big consumer issue. And as I mentioned, I think Europe is already ahead of us on this. They're already thinking about that and exploring ways that they could, at a minimum, make people publicize what is their right to revert. So I agree with that question and think it's a very fruitful area. As to copyright, I just want to agree with Kit that I think that probably the best approach is to look at transforming section 117C to D to maybe get it to work better for software. It's a very hardware specific provision right now, and in the paper that I'm submitting, I actually gave a possible revision that we could make to section 117. I agree fair use is a good avenue, but I think it's better to have something baked into the statute, and we already have a good start in 117. Thanks.
Yeah, if I could, I'm
Yep.
going to speak to both questions. One is, the right to revert is something that when a printer company pushed a security update that included DRM that kept you from using third-party ink that you had bought, we launched a public shaming campaign and got a new non-DRM version available for customers, but that deters people from installing security updates. So I agree both with everyone who has spoken on it, as well as the person who submitted the question, that right to revert is really important when a company might push malware to your device. And then in terms of fair use, I think fair use has to do a lot of work, and it can be expensive to defend as a practical matter. Having a clear safe harbor is preferable, as long as that safe harbor isn't read in the inverse sense to mean that anything outside of it is necessarily not a fair use. And I think it's important to note the fairly counterintuitive reality, which is that the dominant view of the courts is that Section 1201 eliminates fair use, or at least it does not include it for the anti-circumvention right. And so even if you are circumventing to achieve a fair use, you can still be liable, even criminally liable, under Section 1201. If we win our lawsuit challenging this law on First Amendment grounds because of all the ways that it interferes with speech, then I think that would be a great way forward, but we'll see what the panel says.
So I'll just jump in on the patent issue. The problem with abuse of rights or misuse is that typically it's used for when you extend beyond the scope of the right. The Federal Circuit's jurisprudence is just so bad right now that it's unlikely that they would act. The other problem with misuse is that it doesn't really act as a strong enough deterrent. So similar to Leah's bonding concern, you don't have liability for the assertions that go beyond what they should. So this is why really using antitrust law with treble damages is so critical, and why it actually really should be an FTC issue. Again, I hope to hear that the FTC is going to vigorously pursue this to say that, yeah, you may have a right, but that doesn't mean you can't abuse this by taking away people's right to repair. So.
Great. So thanks very much for these remarks. Anyone who knows me well knows that I like to be on time. So I'm going to say we are have many more questions, and I'm sorry we're not going to be able to get to all of them, but I think everybody deserves a little bit of a bathroom break, and we will start again right on time at 10:20 Pacific. So thanks again to the panel. It was really wonderful stuff. So thanks again. Great.